by the Metropolitan Law. My name is Umahani Ahmad Amin, the managing partner of the Metropolitan Law Firm, and I am going to be moderating this program today. This program is the first lecture of its series, with today's topic as Al-Wassiya, that's tailoring your succession plan. Present with us here today is Rotimi Obende, Senior Vice President of FBN Quest Trustees, Jibril Salahuddin, he's the CEO of CityServe, and last but not the least is our Dr. Bashir Aliyu, the Vice Chairman of the Financial Council of Experts of the Central Bank of Nigeria. Good morning, Mr. Rotimi. Good morning, Mr. Salahuddin, and good morning, Dr. Bashir.
Good morning, Umani.
So this lecture series is geared towards focusing on the most relevant and prevailing issues in the Islamic estate planning and administration space. And today's topic is one of the most central elements. Wills are considered as a basic legal instrument with regards to estate planning. Understanding the
Good morning once again. I guess we've lost the moderator. My name is Rotimi Obenda. She has introduced me, and I'll just basically take us through some of the things that have happened so far in the Islamic finance space, which has given us the opportunity to be able to also talk about Islamic estate planning. I represent FBN Quest Trustees. I'm responsible for strategy. In terms of what would essentially be looking at this morning is, again, just to let you know that tailoring our succession plan is part of what we intend to talk about this morning. However, like I said, I'll be looking at it from a different perspective. In terms of the Islamic finance market, just putting some numbers out there for us to be able to appreciate where we are so far. On the global scale, where the Islamic finance market is estimated at over 2.6 trillion naira. There are over $1 trillion. There are over 2,000 Islamic institutions that currently account for that. In terms of presence, there are 41 Islamic countries where you will find Islamic finance being discussed, and they have lots of products, and 39 non-Islamic countries. Key countries for us to watch out for: Malaysia, they have about 132 products or institutions. Bahrain, 74. United Arab Emirates, 71. In terms of the institutions that currently offer different products across the Islamic finance spectrum, you have more than 300 microfinance institutions with over $1.6 billion, over 300 plus sukuk currently in the market, and over 750 Islamic funds. In terms of why we also believe that there's so much happening out there in the Islamic finance space currently, if you look at the ecosystem, there are over 1,526 Islamic financial institutions. If you're looking at research research materials, published research materials, there are over 2,500. If you are looking at Islamic events, which will again class this one at, you are looking at more than 463. In terms of news items, you find over 13,000 out there in the market space. There are over 1,000 plus Islamic scholars, and that essentially gives us an idea that yes, there's so much that is happening in that space. In terms of how we arrived at the over $1.8 trillion, you find out that Islamic banking currently accounts for 69%. Islamic funds just contribute 5%. Sukuk accounts for 19%, and so that's the distribution you find there. In terms of growth, from 2007 to about 2019, the Islamic finance market has grown consistently, and I'm talking about compound annual growth of 10%. You can hardly find out in most markets these days. In terms of some breakdown, like I said earlier, the Islamic banking currently occupies the largest pie of the financial assets at 69%. The size of the market is about $1.9 billion. There are about 526 institutions. So just looking at this chart, it gives us an idea of the number of institutions that currently offer Islamic products and that currently account for how huge the market is at the moment. For Nigeria, we see a lot of potential coming, basically just looking at it from where we've been. We also see that there's high liquidity in the Islamic market. New products are coming up. There's a lot of diversity that is currently taking place. The first Islamic bond was issued in 2012 by the Osun State government. And since then, the federal government has successfully launched and issued 3 sukuk, all of them all subscribed. There are 3 pure Islamic banks in Nigeria at the moment, and we see a lot of non-conventional banks. We see a lot of conventional banks, now currently offering Islamic banking products. Stanbic and Sterling are the major ones you talk. Now, in terms of estate planning and how we got to where we are, that gives us the assurance to be able to discuss all of this today. Between 2003 and 2012, there was not much that happened in the market. International Jazz was first a special purpose company. Then Lotus came up. Lotus Capital was formed around that same period. From 2012 to 2015, JS was registered as a fund management company, and thereafter it became a fledged bank operating as a full-fledged bank. Like I said earlier, Osun State issued its first sukuk in 2012, and a lot of commercial banks started to offer and join the fray to be able to talk about Islamic finance. On the global, just speaking to how Metropolitan also came on board between 2012 and 2015, decided to organize the Global Islamic Conference, and I can tell you for free that that's the only law firm that has been offering that conference on a global, on an annual basis. Between 2016 and 2019, again, the federal government had issued 3 sukuk. Jazz has been upgraded to a national bank. 2 other banks have been licensed, and FBN Quest trustees, as a result of skills improvement and knowledge improvement, started to talk about Islamic estate planning. I would say that FBN Quest trustees is the first company that started to talk about Islamic estate planning. Some artifacts that we need to know when it comes to succession planning and how all of these key into what we'll be talking about this morning. There are a lot of family conflicts, even in countries that you do not expect there to be conflicts because of the laws. They have the best laws when it comes to succession planning, particularly with Islam as the backbone. Families will find can become a big distraction when it comes to succession planning. Again, a lot of people are asking themselves, who should be running these businesses? Is it the right of the firstborn as firstborn to take over a company that he has not had a part, or you allow a female to continue to run it because she's been doing that anyways? A lot of business wealth is still found in private hands, as a matter of fact, 80% of family-owned businesses still reside in families. In terms of succession planning and the advanced part, for us, we think that there's still some challenges that we'll need to be able to navigate through. Generational wealth transfer for us is a key when we start to talk, a key part of what we like to talk about, because only 30% of businesses survive into the second generation, 12% survive to the third generation, and when you get to the fourth or fifth generation, there's no business that the family starts to talk about at all. 72% of family-owned businesses do not have a plan in place. 47% of family-owned businesses have not considered estate planning at all, and 7% have only spoken to a professional, either a law firm or a trust company, when it comes to generational wealth transfer. For us, again, just to talk about some of these numbers, when you ask people, a lot talk about the disharmony among family members. Some people say they do not know or even know where and how the conversation should start. And a lot of people still have misconception, particularly when it comes to the sharing formula that Islam has prescribed for us. We find out that the higher your wealth, the tendency for your family members to fight over what you have. As a matter of fact, the Economist in 2016 estimated that 70% of Saudi families have one succession planning issue tied up in the courts. In terms of, so we just put these slides together for us to see clearly that some of these countries that we do not expect conflicts to even arise. There are a lot of conflicts, and 38% in Saudi Arabia, UAE 32%. Again, like I said, these are countries that ordinarily you should not expect any crisis to take place. Now, what is worrisome for us in Nigeria is to know that people have started to take themselves to court over inheritance issues. And again, I'm speaking about Muslims, I'm speaking to non-Muslims. There's a man in court that has dragged his sibling over an inheritance that they received, again, because he thinks that his brother is trespassing when the property was shared amongst them. Again, very disturbing is the son of an ex-governor who has taken the mother to court over the property of the ex-governor. Again, these are just issues that tend to bother us because we know for sure that there's a prescribed formula for how things should be done. Again, this just shows to us that people are trying to navigate things which should not ordinarily be. The Tunisia cabinet is discussing equal inheritance law. Wealthy families in the Middle East are also considering whether their daughters should inherit. Like I said earlier, these are worrying signs for us. However, we do know that when inheritance goes wrong, it is not because it has nothing to do, absolutely nothing to do with the Islamic law. The Islamic law is perfect. We know that it has everything to do with people. And so because of this, partnering with the Metropolitan Law Firm, we decided that there are a number of things that we need to really put in proper perspective. So a lot of collaborations and partnerships have gone into producing or ensuring that a program like this takes place, conferences and events. We do speak to small groups or large groups making presentation, even on the radio and on social media. Now, for us, we've been able to identify with some key partners, Dr. Ziad, for example, Dr. Bashir, who will be speaking to us, and Uman, who is a principal partner at the Metropolitan Law Firm and the Metropolitan Law Skills. These are the partners that we currently work with today to be able to ensure that Muslims plan their estate in the right way and in the right manner. Again, just to put some context to how we are currently structured on the legal side, Metropolitan Law Skill is responsible for drafting and ensuring that all the legal documents are in place. Dr. Bashu is our advisor when it comes to structures and when it comes to the nature of investment, just ensuring that it's tailored along the Islamic line. So when we speak to our clients, which you find up there, we are able at FBN Quest Trustees to manage their assets and manage their estate such that there are minimal criteria crisis or no crisis in future. A lot of this we've done in time past. We've done this through some conversations like the estate planning clinic that we had in 2019. We started to have all of these programs from 2018, and we've consistently managed that. Just to show you some of the events that we have had, if you look clearly, you might be able to identify some of the people that we put out there. In 2020, just before the pandemic, we had the e-talk of the former strongman of Nigeria discussing inheritance issues and how all of this can be structured for the future generation. Last year, we had quite a number of series again, which we've started to do this year, all talking about preserving our generational wealth and how each generation, if you see the statistics that I showed earlier, such that it's able to go even beyond the third generation. So we've been having all of these conversations, and we believe that everything is just geared towards ensuring that we have the proper context. In terms of products, we can discuss estate planning, we can discuss Islamic wills, we can discuss Islamic trust, we can even discuss zakat and be able to put structures in place for us to ensure that, again, like I said, the next generation is taken care of. That's my presentation this morning. Thank you very much. Over to you, Mahani.
And hello? Okay, can you hear me? Thank you very much, Mr. Rotimi. And I apologize for that cut. We had a few hitches with the network in the office. But be that as it may, I enjoyed, as always, your presentation because it brings out what Metropolitan Law Firm can do, and of course, Metropolitan skills. Thank you very much and it's always very good to hear from those in the industry. Thank you. So we shall now proceed to hear a presentation from the COO of CityServe, Mr. Jibril Salahuddin. Please feel free to send in your questions as the presentation is going on. All questions will be answered at the end of the presentation. Thank you. Please, Mr. Jibril Salahuddin, you're welcome.
Distinguished ladies and gentlemen, good morning. Can you see my slide, please?
One moment, please, while we wait for Mr. Jibril Salahuddin to connect. We are trying to.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم والصلاة والسلام على أشرف الأنبياء والمرسلين سيدنا ونبينا محمد وعلى آله وأصحابه وسلم. Assalamu alaikum wa rahmatullahi wa barakatuh. Good morning, ladies and gentlemen. My name is Jibril Salahuddin, and I pray my slide is up now. Can you see it? Okay, good. I can see Mr. Rotimi nodding his head, which shows maybe the slide is up. Lovely. Thank you. Thanks for that signal. If I take the earlier presentation by Mr. Rotimi into context, there wouldn't be a need for me to present anything. Because if you look at the quality of that presentation and the numbers that have actually come out of it, it will be sufficient for us. It will be sufficient for us to actually ponder on. And so let me make a confession. Yesterday, I called my daughter to take a look at the presentation because I didn't put it together. I wanted her to do an edit for me to take away typos. And so she looked at it. And she is an investment banker. And she came back to me and said, Daddy, do you have your Wassiya? And I was quiet. I mean, the question, and I want us to ask each and every one of ourselves this morning, do we have our will, our Wassiya? Do we have it? You know, if we have been having a live program, I will have stayed by the gates and I'll ask Dr. Bashir to help me count the number of people who do not have their will. And we can just separate people apart and count, and you'll be disturbed by the numbers. So when Mr. Rotimi did a presentation and spoke about family business to not seeing the third or fourth generation, it's completely different. And my experience at the Lagos Business School is different. As a faculty, what we've discovered is that only 9 Nigerian businesses has crossed the second generation. Only 9. And I've been at this for a while. And the very few that have seen the second generation, something different about them. And one of the things that is very different about them, which we're discovering, is what Islam has put in place years back. And that is the will. So if you put that into context and you look at what he has said this morning, there is a lot to think about. Now, so my daughter asked me, do you have a will? And I said, I used to have one. And between last night and this morning, I was busy searching for it, sieving out tons and tons of papers. And I now discovered that those wills are actually outdated. And I need to have updated them 3, 4, 5 years back. And this is something I need to have been doing consistently. And this is what all of us must put into mind, and we must put into perspective. Now, the second thing I want to mention before I go into my presentation is about my father, Sheikh Salahuddin. When he was on his sick bed before he passed on, his friend came to him and they asked him, what have you done about your Wassiya? And he said, there will actually be nothing about it. And so they asked, why? He said, because when I pass on, there will be nothing to be shared. And indeed, when he passed on, there was no fight. So Rotimi, you are correct. People who leave something behind also have things that do be shared. We became very, very friendly. All of us became friends because there was nothing to be shared. And you might be wondering, so maybe the number is not big. I'm child number 16 of 19 children. So it will interest you. But we couldn't fight. There was no reason for us to fight. But so what I'm trying to do here is to bring out for you the essence of this Wassiya. Today, alhamdulillah, we are blessed. We have the Metropolitan Law Firm, we have the FDN Quest, and we have the like of Dr. Bashir around us to guide us and say, this is what we need to do with our Wassiya, to have our will. I implore you, this is not just an interesting presentation. No, it's not. That's not what it's designed for. This is a technical presentation for which we need to go back and action it. Talk to our neighbors and talk to the next person and talk to the next set of people and talk to every HNI and individuals around us. The importance of having a Wassiya. For me, I have made up my mind. I'll be visiting the Metropolitan Law Firm from tomorrow, inshallah, and I'll get my Wassiya done properly. Okay, so let's go into the presentation. So our learning objective will be to arouse awareness on Islamic will, to consult an Islamic scholar or legal expert on what we need to do. We don't need to go far. Good enough for us this morning. All of them are on this platform. My other brother, Dr. Bashir, is here. My sister, Omani, is here. My friend, Rotimi Obende, is here. So everybody is here. You can just take it for free. Because one thing is sacrosanct. we must all pass on. It's a must. One day, someday, sometime, we must all go. And so it behoves on us to say that what is it that we need to leave behind? Very important. So we have an opportunity through this to even fix what is going to happen behind us. We have an opportunity to fix some of the things that will happen behind us and to ensure that the will complies with Islamic law as well as the law of the country of our residence, Nigeria today. For those of us who live in the southern part of the country and the Sharia law is not part of our law, we have even a more urgency for us to take care of a number of things quickly. Because, I mean, I saw the few links that has already posted. I'm sure if you had gone into the papers and what is happening in southwestern Nigeria, you will see so many frightening revelations. Frightening revelation. There is hardly a week, and I'm saying this with all sense of responsibility, there is hardly a week that I don't sit down to talk to people, children of the deceased, to sort out issues of will, even though this should have been done by the deceased himself, because I am also a secretary of one of the Muslim cemetery in Lagos. And I know the kind of trouble. From the point of burial, you see fights. From point of burial, you see people fighting themselves. And I'm happy now that I now have my sister to disturb and I have Rotimi to disturb, and you guys are in trouble. Because when these guys come with their case, I'll just send them to you straight. And so you can go and solve them, and I can get some nights to sleep, and the pressure will be on you and Dr. Bashir. Thank you for inviting me here, and you have solved part of my problems. Okay. So what is Islamic will? What is Al-Wassiya? What is it about? Well, the name is Al-Wassiya, and we say it's a transaction which comes into operation after the testator's death. The will is executed after payment of funeral expenses and any outstanding debts. The one who makes a will, the Wassiya, is called a testator, Al-MUSI. The one on whose behalf a will is made is generally referred to as a legatee, LAHU. So we see what a will is. It's a will important, extremely important for us as Muslims on so many fronts. One, it gives you an opportunity to earn the hereafter. The major goal of any Muslim is to earn Jannah in the hereafter. May Allah make it possible for all of us. Ameen. Now, in Sahih Bukhari, the Prophet ﷺ said, it is the duty of a Muslim who has anything to banquet not to let 2 nights pass without writing a will about it. If you have anything to banquet, to leave behind for people to take, do not allow 2 nights to pass without putting together your will. No, I don't have enough to banquet, might be some of the arguments. If you have as much as 2 sa of a date, you have something to banquet. As small as 2 sa. Now, when I say 2 measure of a date fruits, something as small as that, you have something to banquet. A man may do good deeds for 70 years. The Prophet ﷺ said this. For 70 years. But if he acts unjustly, when he leaves his last testament, the wickedness of his... Can I continue? All right. The wickedness of his deed will be sealed upon him, and he will enter the fire of hell. If, on the other hand, a man acts wickedly for 70 years, but is just in his last will and testament, the goodness of his deed will be sealed upon him, and he will enter the garden of Jannah. This is how important, and you can find this account in Ahmad and Ibn Majah. This is how important the will is. And this is coming from the Prophet sallallahu alaihi wasallam, and these hadiths are classified as sahih, authentic. If you're looking for the musnad and the matnan and the chain of transmitter of this hadith, you can ask Dr. Bashir, he's here. If you're looking for the isnad and the chain of transmitter, ask him. Now, what are the attributes of a wasiya? When we say the will, what are the attributes of the will? It's one, the will on its own gives the testator an opportunity to help someone. A relative needs such as an orphan, a grandchild, a widow, who is not entitled to inherit from you. It could even be a Christian, a Jew, who is not entitled to inherit from you. But since you have set this apart, you can say, okay, so give so-so and so-so and so-so. The calculation, the detail of it, how it is done, that is not my job. The job, Rotimi is here, Umwani is here, Dr. Bashir is here, they will give you the detail of that. And don't assume that you know it and you can go and do it on your own, okay? Consult the experts before somebody drags your will to court and they make a nonsense of it. This can be used to clarify the nature of joint accounts. A lot of us hold joint accounts with our wives, with our children, with our other partners. We hold joint accounts. How do you clarify it when you're gone? Those living in commensality, appointment of guardian for one's child, and so on. In countries where the intestament succession law is different from Islamic law, it becomes absolutely necessary to write a will. In some part of northern Nigeria, you still find the Sharia law in place. But for us, like I said, whether you are in northern Nigeria or you're in southern part of Nigeria, it is important for you to look at your will again and get experts to draft it for you. Let them document it for you and let them advise you on it. It's very important. There is nothing that has kept me awake in the last few weeks, like being given the opportunity to look at Al-Wassiya with you this morning. The last couple of days that I've been working on this, I've done editing for a lot of Islamic journals. And during my PhD program in Islamic finance, I've done a lot of work on different areas. But majorly, they are probably for me to pass exams. I just realized that. And today, I'm looking at it from a different perspective. And it's from the perspective of course, when I pass on, what happened? Don't say I'm too young. My younger sister is late. So if it is by age, I'm supposed to have gone before her. So it's not by age. So once you have reached that age of puberty, you need to put it together. I will discuss that very, very shortly. So the Islamic wills include both bequests and legacies, instructions and admonishments, as well as assignments of rights. What are the debts that I'm owing? What are the things that I need to repay? What are the things that have been put into the business? What are the things that have been kept with me? What are the instructions that I'm giving? What are the admonishments that I want to give to people? Because that admonition is no longer useful for me, it's only useful for people who are alive. When we give admonition, when people die and we go in and we give admonition, we give WASI, and the sermon is being presented, it is not useful for the deceased. It's only useful for people who are alive so that they can learn one or two things from it. So what are the assignment of rights? So you ask the expert for wording that are necessary for making a will. It's very, very important that you consult the expert for this. In Islamic law, the will, which is the wasiya, can be oral or written. For admissibility, proper admissibility in law, we advise that you have it written. And the intention of the testator must be clear that the wasiya is to be executed after his death. Any expression which signifies the intention of the testator is sufficient for the purpose of constituting a bequest. So today you have 2, 3, 4 houses, or even one. And so how do you want to share it? You have orphans that have lived with you. You have people in the community that you want to assist. And you think, no, you can leave it till tomorrow. Who tells you you're coming back? Where did you get that assurance from? So it's very important for us to constitute a banquet and make sure we leave our wasiya behind and do it properly with the experts. There should be 2 witnesses to the declaration of the wasiya. A written wasiya where there are no witnesses, or an oral declaration, is valid if it is written in the known handwriting stroke signature of the testator according to the Maliki and the Hanbali fiqh. The wasiya is executed after payment of debts and funeral expenses. Of course, as a Muslim today, the first thing that you'll be asked, your family will be asked when you die is, who is he owing? So if you're not documenting it, how do we know who you are owing? So it has to be documented. Who is he owing? How much? And this is another area where we need to call our attention, and we need to fear Allah in what we do. Today, when you ask, who is Jibril owing? Everybody, 4, 5, 6 people will come forward and say, he's owing me this. And you say, who are the people that are owing him? People remain quiet. People remain quiet. But once people are owing you, please put it down so that it is also known and it is referenced. So the majority view is that debt to Allah subhanahu wa ta'ala, such as zakah, obligatory obligations, expiation, etc., should be paid whether mentioned in the will or not. And I love, like I said, I love the presentation by Rotimi, and I say it will have sufficed if I didn't even say anything. Because he said it here, part of the thing that they do is that they also help you to plan your zakat. And so your zakat is known from your earning and from your savings. As such, there won't be any trouble. As soon as you are gone, the detail is known, it will be paid out. And so the obligation which belongs to Allah has been taken out. However, there is difference of opinion on the matter among the Muslim jurists. So the testator, Al-MUSI, who will be Al-MUSI, every Muslim who is Al-Mukhtar with reasoning ability has the legal capacity to make a will. Once you have attained puberty, details of puberty are found in the books of fiqh. Once you have attained puberty, you can make a will, and you are in your right senses. You are mukallaf. An adult for this purpose is someone who has reached puberty. The Maliki and the Hanbali fiqh also consider the will of a discerning tamyiz child as valid. Under the English law, you must be at least 18 years of age to make a will. The testator must have the legal capacity to dispose of whatever he bequests in his will. So you don't say, okay, so I'm bequesting this, and you do not have the legal capacity on it. No, you can't do that. So once you get to speak to the expert, they will find out the details of everything that you want to bequest, and they will tell you your limitation. And this is why this expert and professional services becomes very, very important. In fact, in most Muslim countries around the world, or where Muslims have actually emancipated themselves, these services are always there. And we've seen, and part of what was to be presented today on Waqf, we've seen in Muslim countries where Muslims have actually dedicated a lot to Waqf. 4 years ago, we were in Turkey, and we saw a Waqf that is 630 years old. And what the Waqf does is that they use the Waqf to feed migrant birds. Amazing. They use the Waqf to feed migrant birds because the birds have different seasons, so they migrate. So when they migrate at that particular season, there are not enough food. So some people have come together to put together a Waqf that feeds this bird, and the Waqf is 630 years old. And all of us want to go to Jannah. It's interesting. So we need to do more. And this is a wake-up call, like I said, for all of us. Again, for the testator, the Al-MUSI, when making a will, the testator must be of sane mind. The testator must, of course, own whatever he or she bequests. He or she must not be under any compulsion, and he or she must understand the nature and effect of his testamentary acts, the testator has the right to revoke his will by a subsequent will. Actually, or by implication. So in traditional Sunni Islamic law, the power of the testator is limited in two ways. One, firstly, he cannot bequest more than 1/3 of his net estate unless the other heirs consent to the bequest, or there are no legal heirs at all. Or the only legal heir is the spouse who gets his or her legal share, and the residue can be bequeathed. Narrated by Sa'ad ibn Abu Waqqas, radiallahu anhu, he said, I was stricken by an ailment that led me to the verge of death. The Prophet sallallahu alaihi wasallam came to pay me a visit. I said, O Allah's apostle, I have much property and no heir except my single daughter. Shall I give 2/3 of my property in charity? He, the Prophet sallallahu alaihi wasallam, said, no. I said, half of it. He said, no. I said, 1/3 of it. He said, you may do so. Though 1/3 is also too much, but for it is better for you to leave your offspring wealthy than to leave them poor, asking for help. This hadith is in the Sahih al-Bukhari, Sahih Muslim, Muwatta Imam Malik, Tirmidhi, Abu Dawud, and Ibn Majah. So all the muhaddiths are actually, they converge on this. Two important points here. And these are some of the things that the technicalities that the expert will guide you on. What you need to bequest, the importance of the fact that you need to leave your offspring wealthy than leaving them poor. Poverty is a lot of challenge. And we've seen children of people who are seemingly wealthy have become poor because of wrong or poor advice or no advice at all on how to handle their will. In my very young age on earth, I've seen quite a number. In my early career, I used to work as a sales representative for a fast-moving consumer goods company. And I had a colleague who was a depot manager, and he passed on. And 4 or 5 years down the line, his children were struggling. We came together as friends and said, how do we help our friend? And one of the brothers said, no, but while we were working, this guy was buying so much shares, so whatever happens to him? And so we asked the wife, this guy used to have a lot of shares, whatever happened? He said, no, he didn't leave. There was nothing that shows that. Anyway, he has some pack of books there. And we went there and we started checking, and we found a lot of share certificates running into millions of naira. But they wouldn't have known. They would have sold it to an akara seller by the roadside, and that would have been the end. That would have been the end. And a lot like this are happening. And that's why it's important for us to sit with experts, get this thing documented, be in good custody, and we can move on with it. May Allah assist us. For the Al-MUSA LAHU, generally speaking, for a bequest to be valid, a legatee must be in existence at the time of the death of the testator, except in the case of a general and continuing legatee, such as the poor, orphans, etc. The legatee must be capable of owning the bequest. Any bequest made in favor of any legal heir already entitled to his share is invalid under the traditional Muslim law unless consented to by the other legal heir. An acknowledgement of debts in favor of a legal heir is valid. Acceptance or rejection of a bequest by the legatee is only relevant after the death of the testator and not before. Now, we also make some mistake. Some of us will just go to a judge in a court And we say, okay, so this judge, we know this judge in the court, and so he was going to help us to do this. And this happened to me when I returned from Sudan, and I went to do my non-biased Sharia course. And I've seen a lot of people then who come to the court and they will ask the judge to help them write their will. These things are not done. He's also busy, he has so much to do. And in some cases, the technicality to actually do it is not also there. So the more important thing for us to do is to look out for the experts in this and actually talk to them. Generally speaking, once a legatee has accepted or rejected a banquest, he cannot change his mind subsequently. If the legatee dies without accepting or rejecting the banquest becomes part of the legatee estate according to the Hanafi fiqh, because non-rejection is regarded as acceptance. According to the other three main Sunni madhab, the right to accept or reject the banquet pass on to the heirs of the legatee. How am I doing with time? Okay. So the executor of the will.
You're on course. It's okay.
Thank you.
Go on.
I don't want to get into Dr. Bashir's time because I want to listen to you very well as well. Okay. So the executor of the will, Al-Wasi, Al-MUKHTAR. The executor, the Al-Wasi of the will, is the manager of the estate appointed by the testator. So here, the metropolitan law firm will be the executor of the will, the FDN quest will be the executors of the will, and so they will be there to look at the details of this. And the executor has to carry out the wishes of the testator according to the Islamic law, to watch the interests of the children and of the estates. The authority of the executor shall be specified. Hanafi and Maliki fiqh states that the executor should be trustworthy and truthful. The Shafi fiqh states that the executor must be just. The Hanafi fiqh consider the appointment of a non-Muslim executor to be valid. So all the qualities, before you see a Dr. Bashir signing on anything and saying it's on their board, he must have checked all of this to make sure that they are not only trustworthy, they are also truthful, they are just before he sits on it. I've known him for years, and I know the kind of person that he is, and he will not sit on anything. Somebody tried to say something the other time that doesn't come from him. One guy, we just called him and he said, no, that's not my signature. I'm not the party to it. The testator may appoint more than male or female. The testator should state if each executor can act independently of the other executor or executors. If one starts acting as an executor, one will be regarded as having accepted the appointment, both in Islamic law and in English law. Sorry. So should we have a situation where we have two executors, and if I have two executors to my wasiya, I must also mention this in my wasiya. And I must also mention if they can act together or they can act independently. And if one of them commences acting while the other is to join later, both in the Islamic law and in the English law, it is both acceptable. So this is the brief I will be sharing with you this morning. I'm sure we'll get further details, inshallah, from Dr. Bashir. Whatever I've said here that is in cognizance with the Sunnah of the Prophet ﷺ, may Allah accept it. And whatever mistake I've made in this presentation, it is from me and it's from the shaitan. May Allah forgive it. Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh. Thank you.
Wa alaikum assalam, and thank you very much. From your presentation, we have all learned that it is very important. As lawyers, we have always had issues with trying to tell a client that, but then of course it is something that we all need to do. It's something that we are not able to make any gift or anything else we want to be done after our demise. And that's why Allah has provided, and of course the traditions of the Prophet has provided that you can be able to will out 1/3 of your property and only 1/3 according to the prophetic tradition. Thank you very much, Mr. Salahuddin. And I am looking forward to being your lawyer, trying to draft a will. Thank you for the first brief this morning. Thank you. And now we will go back to Dr. Bashir Aliyu to be able to dissect everything we need to do to know about the wills, about succession. And inshallah, we will leave here being very enlightened. Thank you very much. Assalamu alaikum, Dr. Bashir.
Wa alaikum assalam wa rahmatullahi wa barakatuh, Hani. Bismillahir Rahmanir Rahim. Alhamdulillahi Rabbil Alameen. Wassalatu wassalamu ala ashrafil anbiya'i wal mursaleen. Sayyidina wa nabiyyina Muhammad wa ala alihi wa sahbihi ajma'een. Amma ba'd. Fellow panelists and distinguished participants in this webinar, Assalamu alaikum wa rahmatullahi wa barakatuh, and a very good morning to you all. It is indeed an honor to participate and present in this masterclass on Islamic estate planning. And my younger brother, Dr. Salahuddin, Dr. Jibril, he has indeed given what is expected about Wassiya, all the salient points, all the needed fiqhi issues under Wassiya properly covered by him, with even indications on areas of differences among the scholars. Alhamdulillah, this is a very good thing. So most of what I'm going to say, maybe it is going to be, you are going to have some repetition. So just bear with me. I hope it will not be boring to you. But since this is, as you all know, it's a new field which normally we don't talk about, because most of our conversations regarding fiqh, they are limited to the section of ibadat, the acts of worship, prayer, saum, zakah, and hajj. It is only rarely do you find people going into these areas of fiqh al-mu'amalat, that is commercial and business transactions and other transactions relating to finance and also the family. So all I want to say is that maybe you will observe a lot of repetition, but the repetition I think will be beneficial regarding Wassiya. Let me share. I have slides that I presented right from I think on different occasions regarding this, and I think yes. So so this is these are the slides that I intend to present regarding Wassiya. I don't know, Hani, am I also supposed to speak about the estate and its about distributing the estate, Al-Mirath?
Yes, sir. Yes, sir.
Okay, then. So I'll go through Wassiya very quickly, because Dr. Salahuddin has already done so. Al-Wassiya is very important in the Sharia. It is mentioned in the Quran, as you heard from Dr. Salahuddin, and it is regarded as a very strong sunnah mu'akkada. And with respect to someone who has obligations on him and who has wealth, it is regarded as obligatory. So it is really very, very important, and its importance is based. One of the things that shows the importance of Wassiya, of a bequest, is that it is done. It is put it is given priority over inheritance. Because as you know, in the order of what happens to the estate, to what a deceased leaves behind, is after the funeral expenses, then comes the settling of his debts, which are the rights of others. Allah Tabaraka wa Ta'ala does not forgive somebody that has the rights of others on him. Those rights have to be settled. After settlement of debts, then comes wasiya, and it is after executing the wasiya that inheritance comes forth. The importance of the wasiya is that it is something which the the testator has the what he does with his wealth out of his free will while he is alive. He has got he has absolute control over it, except of course the limits placed on him by the Sharia, which some of which you've had. And but inheritance, he has got no control over it. It has been distributed, it has been executed by Allah Tabaraka wa Ta'ala himself. So wasiya, you know, it has got this importance with regards to the one who does the bequest. It has also been the practice of it is also the practice that this is something which is to be secured in a legal documentation, because if what happens between people in normal business transactions that involve delayed payments or delayed delivery, we are asked to document them for fear of disputes. The case of wasiya is even more. It is even more entitled to committing it in writing, because it will involve someone who is already dead and who will not be able to defend his right or to make a representation. So that is why the question of documentation in wasiya is given strong importance. My own definition of wasiya is this: that is the transfer of wealth that is either tangible property or use of right by way of donation, but that will only be effective after the death of the donor. So wasiya is regarded as a kind of an act of tabarru, that is donation, an act of benevolence, something which you do not to earn any profit in this world, but to prepare for the hereafter. And this is why it is called what it is, because the meaning of wasiya is one of the meanings of wasiya is connectedness, is connection, because it connects this world to the hereafter. How does it connect this world to the hereafter? You are providing while you are in this world for yourself in the hereafter. That is, you see that you are. This is an extension. Or this is when you go out of this world into the hereafter, this is what you have already prepared for. Just like someone who is living in a government estate, in an official residence, and he knows that his term is going to expire within a fixed period, and he starts planning for his house where he's going to move into. Definitely, if he makes if he puts all his assets and his attention and his wealth into making his life comfortable in the official residence, and he forgot the actual residence that he's going to move into, it will be regarded as an act of foolishness on his own part. So the verse that is regarded as the basis of wasiya is the verse that you had already from Dr. Jibrin. That is where Allah says, "Kutiba alaykum idha ya ayyuhalladhina amanu kutiba alaykum idha hadara ahadakum al-maut in taraka khayran al-wasiya." That is, it is prescribed on you that when death approaches any of you and he is leaving behind wealth, to make wasiya in favor of his parents and the near of kin, in accordance with what is normally acceptable. The mention of parents and the near of kin, they are mentioned because of commonality. It is not a restrictive is not a restriction that wasiya can only be done in favor of parents or the near kin. It can be done in favor of parents or the near kin or even distant relationships. But mentioning parents and the near kin, it shows that the priority is to be given to acts of goodness to parents and goodness to near relations. So wasiya actually becomes an embodiment of a charity and also kindness, goodness to relations, silatul rahim, that is keeping, extending goodness and benefit to near relations, which itself, even though it is an act of charity, but it is a special type of charity. When the wife of Ibn Mas'ud, she asked the Prophet sallallahu alaihi wasallam that my husband is Ibn Mas'ud, he doesn't have much, and I have this, I have money that I'm giving out in zakah. Can I make him a beneficiary of what I'm giving out in zakah? And the Prophet sallallahu alaihi wasallam told her to do so, and he said, "Hiya sadaqatun wasila." It is an act of giving out zakah, an act of charity, and also an act of doing good to near relations. So it becomes a double reward. The Prophet ﷺ also said that it is the duty of a Muslim who has something with regards to which he needs to make a wasiyah, not to spend 2 nights without having his wasiyah written down with him. Now, the mentioning of 2 nights, it is an indication that wasiyah can change, that you can change it. This is what makes it different from waqf. Waqf, once you make waqf, you cannot change the terms, you cannot change the waqf property. But a wasiyah, if you make it, you can alter it, you can add, you can decrease, you can change the beneficiaries, you can add the beneficiaries, you can subtract them. So that is why the position of 2 nights is given. And this is what Malik rahmatullahi alayhi in the Muwatta, one of the Imams, whose madhab is the one that is predominantly followed here in Nigeria, he gave an explanation of this hadith to show that this is the practice regarding wasiyah. Its validity is based on the legal capacity of the person who is doing it. And he can do wasiyah. The excellent thing about wasiyah is that it can be done even when someone is in the state, even someone is ill, and the illness has been termed as terminal. This shows that when you are quite healthy, it is even better. You are even more entitled to do that. Also, a child who has tamyiz, ability to discern between benefit and harm, when he makes a wasiyah, it will be acceptable for him. And also a person who has got legal restriction on the ground of prodigality. You know, you can have legal restriction on the ground of being bankrupt because of the rights of others. You are creditors. And you can be given legal restraint on account of prodigality. If you are a spendthrift, you spend your money without, and you spend your money in vanities, and you don't have priorities. You don't have a sense of a scale of preference in the way you spend your money, and you're not able to manage your money very well. The court can impose on you legal restriction. Whether and in fact, a person who observes that, who has no relation with you, he can even make a case in front of the court, and he will have the locus to demand the court to give legal restraint to such a person on the ground of prodigality. But despite doing that, despite giving him that legal restraint, he has the power to do a wasiyah, because his legal restraint is only on the ground of prodigality. As you heard, wasiyah also is limited to 1/3 of the estate after settling all expenses that are attached to the estate. And this is in order that something appreciable should be left to the heirs. If the wasiyah exceeds 1/3 of the estate, it can only be executed if the following conditions are fulfilled. That is, if there is the consent of at least one of the heirs. At least one of the heirs will have to consent, and the consenting heir should have full legal capacity, and when he consents, then the amount of the wasiya shall be taken out proportionate to the share of the consenting heir or the consenting heirs. So if he decided to bequest 1/2 of his estate, and then the only person who accepted that is one of the heirs, and his share, the estate will have to be distributed to see what is the quantum of the wasiya if it is 1/3, and then what will be the quantum of the wasiya if it is 1/2. Then the additional amount for the additional percentage, which is the 17 and 1/3% of that amount, will be deducted from the amount that is due to the consenting heir to bring the amount to what he had done because he had consented. There has to be a clear formula for the wasiya because it's one of the fundamental elements that are there in our wasiya. And this is where the question of committing it to writing comes into play. And this is where the importance of legal drafting of the wasiya comes. And I see Hani is very, very happy that she's got a client that she's going to do the legal drafting for him. Our very dear Dr. Salahuddin, you already have someone who will do the drafting for you. Any financial transaction by way of donation or muhaba that is done by a terminally ill person, by whatever name he calls it, shall be deemed to be a wasiya. There are acts of wasiya, you know, that even if the person who is doing it has not clearly said it is a wasiya, but if it is going to take effect after his death, then definitely it will be, if he is doing it when he is in a state of terminal illness, it is going to be regarded as a wasiya, which means it will be limited to 1/3 of his property. What is meant by muhaba is that if he decides to enter into a commercial transaction, like selling a property, but at a giveaway price, in order to show goodness to the one he is selling the property to, a house that is worth 10 million, he sells it to somebody for 2 million. It is clearly something that he is doing to show that he has even, it was actually a gift, and the price that is taken is just a token. Now that kind of act is regarded as wasiya, and it will be limited to 1/3 of the estate. So if the amount that he has donated out of this act of giving it as at a giveaway price, if it is more than 1/3 of the estate, then the will-be heirs will have to sanction it before it is executed. A heir should not be you cannot make an heir to be a musala, that is someone. You cannot make him a legatee who will be a beneficiary of the bequest, except with the consent of the remaining heirs. And this is a position which, you know, the Sharia has brought a lot of leeway for people, for parents, and also will be bequeathers to make an intervention in what they see regarding their heirs, especially those who are weak. Like you have somebody who has got a serious illness that is in need of constant medical attention, or a female that is not well educated, that is not well supported by her husband. Even though she will be a heir, it is one thing which, you know, someone who is doing who is living behind such a person, to make a wasiya to her in addition to what she has of inheritance. And then he could also put as part of his wasiya that he implores and he implores, he encourages the remaining heirs to accept and to accept that wasiya. So it shall be the people who are the beneficiary to our wasiya is any beneficiary that is capable of owning the subject matter of the wasiya under the Sharia. Even if there is difference of religion between the testator and the beneficiary, whether he is alive or he is yet to be born, whether the beneficiaries are limited in number or unlimited. It can also be done to a philanthropic cause or to charitable organizations, institutions, schools, mosques, hospitals, graveyards, and similar bodies. Another element of wasiya, which normally it used to be done, normally it is also part of the wasiya that should be included, is to appoint a wasi, a guardian over the living dependents, including children of a son whose father is under legal restraint. This is also part of the wasiya. It is very, very important to do something like this because to leave children without a guardian, especially it is very, very serious. And normally the courts are empowered. If there is no appointed wasi, the court will appoint will appoint a wasi, a guardian over the living dependents, who is normally regarded as muqaddamul qadi, that is the appointee of the judge. So where the Musi leaves an instruction for his zakat to be paid, it shall be treated as a debt on the estate, not as wasiya. Yes, this is very important to realize this. Zakat is regarded as a debt, but a debt that is the debt of Allah. It should not, if he makes a wasiya that there is a zakah that is supposed to be paid, which he had not paid, or there is a debt that is due to him that will be collected, and when it is collected, it is subject to zakah, and he makes and he specifies that such debt he makes a wasiya to include that as part of his bequest. It will not be treated as a bequest, it will be treated as a debt. So it will be taken out of the estate before the execution of the wasiya. Where he leaves an instruction for obligatory Hajj to be performed on his behalf, that shall be treated as wasiya. Hajj will not be treated as zakah will be treated, because Hajj has got an element of ibadah in it, of action, of service, besides zakah, which is a purely financial act of worship. So if it is Hajj that will be done to him, it will be treated as wasiya, because Hajj, when you have not been able to do it during your lifetime, and then because of anything you make a wasiya that it should be performed on your behalf, that will be treated as a wasiya. So it cannot be more than 1/3 of the estate. Wasiya is an estate planning tool that could be used to entitle non-heirs to the estate. Yeah, this is very, very important. You know, sometimes some examples which the fuqaha normally give is where a testator, he leaves behind the children of a son who has died, and he has other children, but he has some grandchildren whose father is dead, and he has these grandchildren, the sons of their grandfather are their uncles. So because they have got uncles, they are not entitled to inheritance. And if their father was alive, he would have been entitled to the inheritance with which he can take care of them. So this will be a way whereby the testator can plan for the benefit of this category, of this type of category of people who do not have an entitlement to the estate, but they are so near to him. They are themselves children, because in the absence of their uncles, they will be the ones who will inherit the estate. They will be the heirs to the estate. But because of the existence of the uncles, they are deprived. So it is one way whereby he can make a planning for them to as dependents after him. So there are factors that vitiate a wasiya, which is very, very important for the one who is doing wasiya to know, and also for the beneficiaries, as well as for the legal drafters of the wasiya. If it is revoked by the testator, it becomes invalid. It becomes becomes vitiated, because wasiya, the testator, he has got the absolute right to modify or even to revoke it. If the beneficiary, where the beneficiary dies before the testator, then definitely it will the beneficiary, the wasiya will not be inherited by the heirs of the beneficiary, because it has not taken effect. It only takes effect after the death of the testator. And it happens that the beneficiary had died before the testator, so the wasiya in his favor becomes cancelled, because it has not reached the state of execution. Where the beneficiary refuses to accept the wasiya after the death of the testator on the condition that he's of full ahliya, that is, when it comes to be executed, then the beneficiary refuses to accept it for one reason or the other, then definitely it becomes vitiated. Intentional or unintentional killing of the testator by the beneficiary, whether alone or jointly with another person, or causing his death, provided the beneficiary is sane and adult as at the time he committed the act, it also invalidates the wasiya, just as intentional or unintentional killing of someone who bequeaths an estate will deny the heir the right to inherit. The same applies also in the case of al-wasiya. Destruction of the subject matter of wasiya or interest of a third party interest becoming attached to it, where the subject matter in both cases is specified. Now, if there is a specific asset, which is the subject matter of the wasiya, and then it becomes destroyed, then the wasiya is vitiated. Or the interest of a third party becomes attached to it. It has become, maybe it is the subject matter of a debt transaction and it's serving as a lien, then in such a case, the wasiya becomes vitiated. Apostasy of either the beneficiary or the testator, as long as he does not revert to Islam before the execution of the wasiya, it also invalidates it. If the beneficiary of the wasiya, if he becomes one of the heirs of the testator, it becomes invalid, except with the consent of the remaining heirs. So it will be treated as a wasiya to a heir. That is, it will not find execution except if the other heirs, the remaining heirs, become consent to it. And whereas only some of the heirs consent, then it shall be taken proportionately from their share, as we mentioned earlier. Okay, now after this, after wasiya, it comes the estate. So this is the final estate planning tool. Regarding the estate and its distribution, which is called a tarika, it is distributed under the laws of al-mirath, which is a very detailed and comprehensive part of Islamic jurisprudence. And it is one of the knowledges, one of the fields of knowledge that the Prophet ﷺ has bequeathed to the Ummah. It is, you don't have any control over how it is distributed. The only thing you need to know is to know the basic principles regarding it, because the distribution is not left to you. It is in the it was done by Allah Tabaraka wa Ta'ala. So this the tarika is wealth and rights that are left by a dead person. Wealth is inherited. The same also with rights, the rights to occupancy, the rights to a use of right, the right to a shuf'a, that is the right of first refusal. These are all part of a tarika. They can be inherited. These are what constitute an estate. Regarding assets, real estate, cash and bank accounts, stocks and other securities, a takaful policy, especially a family takaful policy, retirement benefits, and personal property. These are all assets and they constitute part of the estate. Regarding rights, we have rights to a lease contract. If you already entered a lease contract, your heirs will step into your shoes. Rights over collaterals, If there is a collateral which you collected on account of a loan which you gave, that collateral will also be inherited. That right to the collateral will be inherited by the heirs. Also rights in a mudaraba contract. When there is a mudaraba contract, like you have you open an investment deposit account with an Islamic bank, and then when death occurs, what we decided in the Central Bank Financial Regulation Advisory Council regarding this is that transactions on the account should be stopped until they get a written instruction from the heirs that the account should continue. Otherwise, if there is any loss as a result of the continuous use of the of the continuous investment activity on the account, then the managing institution, the investment agent, which is the financial institution that is managing the investment, will bear the loss, because it will be regarded as an act of negligence and breach. This is because in a mudaraba, the rights of the Rabbul Mal, the right of the capital provider, can be inherited by his heirs. So because they can be, it becomes a part of the estate that they inherited. So they are the ones that have got absolute control over it. They could decide that the investment activity should stop. So this is why this treatment is very, very important. And this was the position taken by the phrase with regards to Islamic banks. But the practice definitely with fund management entities could be different, because they are not regulated by the central bank. Also, gifts that are reverting to the donor because of lack of fulfillment of conditions. This is a right, which could be inherited also. If you give out a gift and then the gift before it is possessed, because before it is possessed, something happens that the donee, the beneficiary, was not able to take possession. So it is the judgment is that it is reverting back to the donor. Then that will be inherited as well. Wasiya, that is, if the deceased is a beneficiary to a wasiya, that wasiya is a right, which will also be, even though it translates into an asset, but originally it is a right. So that right will be inherited by his heirs. It will be regarded as part of the estate. Ruqba, umrah, and temporary waqf. Ruqba is when you give a person a property, a house, and you give him the right to the usufruct of the house for a period of time. And umrah is when you give him the right, the right to live in a house for the entire tenure of his life, and after his death, it will revert back to you. Now, if there is such a right, then such a right will also be part of the tarika. Of course, umrah will be different, but in principle, if there is a kind of umrah that does not say that it will revert back to the original owner, that action could be regarded as subject of being part of the estate. Also, a waqf that is temporary, that is a temporary waqf that is not permanent. It can also be inherited, because that is when you are a beneficiary to a waqf that is temporary. Then with the death of the beneficiary, his heirs, they enjoy that benefit. So how is the estate distributed? The distribution of the estate is distributed after knowing the rights that are attached to the estate and the sequential order of distributing those rights. We've in the slides earlier, also in the presentation of Dr. Jibril, he made reference to that. And this is briefly, this is the first thing you do with the estate is to redeem mortgage property. Then funeral expenses will follow. Then payment of all the debts of the deceased, including the debts of Allah, like zakat and kafara. Kafara is what you like expiation. For instance, you perform an act during Hajj and you are supposed to slaughter an animal and you did not do that till you came back. And then when death occurs, that is regarded, that the slaughtering of that animal is regarded as part of the, is regarded as settling, it's regarded as a debt which will have to be settled as in the third place in the sequential order. Then execution of Wassiya, then sharing of the residue of the estate to the heirs as provided by the Sharia. The basis of inheritance in Islam is marriage or lineage. Marriage, that is, it's what entitles the husband to inherit from his wife and entitles the wife to inherit from her husband. And lineage is what entitles the other heirs, whether the heirs that have got a specific portion or the heirs that are supposed to take the residual of the estate. The conditions for entitlement to inheritance are these. That is, first, the death of the person has to be inherited has to be established, either in fact or in law. In fact, that is, he's actually dead. In law, when a court makes a judgment that such a person is considered as dead. That is, if he's a missing person, usually after his wives, if he's missing in period of tribulations, like in periods of lots of in these periods of kidnappings and unrest and insurgency, if such a person is missing for 1 year without having any news from him, then the judge can divorce, exact a judgment of divorce on the wives, and the wives can go and remarry. But if it is in the period of peace, then they have to wait for up to 4 years. And after 4 years, they will be given the chance to, their marriage will be ended and they will be given the chance to remarry. But he will not be considered as dead regarding the distribution of his estate till he has reached the a number of years that normally his generation will be regarded to have all passed away. And normally the age most of the jurists they said is 70 years. So when it is when a period of 70 years has come, then the heirs will present the case to when he would have lived 70 years, then the heirs will present his case to a judge, and the judge will pronounce him dead. Only then will the estate be distributed. The second condition is that the heirs have to be established that they are alive before the death of the person to be inherited, either in fact or in law, or even by presumption. Because if, for instance, there is a car accident and they both die, the one to be inherited and the heir, they both die, and they are, each one can be the heir to the other. So determining who died first, sometimes it could only be done by presumption. So if it is done by presumption that the heir died after the deceased, then his own heirs will inherit his share from the first deceased. But if it is ruled that he was the one who died before the estate of the first estate, the estate of the first deceased, then his own estate will also form part of the estate of the first estate that we are mentioning about. The third condition is that you have to establish the relationship between each heir with the deceased. A relationship has to be established, which is the basis of inheritance. So if there is any contention regarding the relationship, then that could be contested. And for issues like this, normally they have to be decided by a court of law, because this is not a question that will be decided by a juristic verdict, a fatwa. A fatwa cannot decide such a thing because there is contention. There is litigation in it. There are things that prevent inheritance. Murder, where an heir intentionally killed the person to be inherited. solely or in connivance with others, or he caused the death of the person to be inherited, such an heir shall not be entitled to inherit from the estate of the deceased. Where the murder is unintentional, the heir shall not be entitled to inherit from the diya only, but he shall be entitled to inherit from the estate of the deceased. That is, if he killed, if the murder is unintentional, like they are driving together and he was, they are in the same car and he was driving and he came to overtake, and then there was an accident. When overtaking, when going in, a car hit the passenger side, and the person who died, he is established as someone who will be a benefactor to him in terms of inheritance, like he's a father or he's a brother. Here, the heir has become the cause of the death, but it was unintentional. So in such a case, where he is supposed to pay the blood money, the diya, which is the compensation for killing him, except of course if the remaining heirs, they all agree that they have pardoned him, or they say that they will accept an amount less than the actual diya. The actual diya now, this week, the value of the diya is about 93 million naira. Maybe people, when they get to know it, they will start not pardoning. But here, most of the time, people pardon regarding diya. But when they get to know the amount, sometimes, you know, people, when they see such a huge amount, especially now that you see young men, because of lack of influence of religion, they are always eager that their parents should die so that they will inherit. In such a case, the question of this kind of settlement and saying that we'll settle for less, people will no longer be doing this act of goodness. While Allah has said, فَمَنْ تَصَدَّقَ بِهِ فَهُوَ كَفَّارَةٌ. Whoever donates that right, expiation for him. That is, it will be a cause of forgiveness for his sins. Anyway, in such a case, the one who caused the death, the unintentional death of the person, he will not inherit from the diya, but he will inherit from the estate of the deceased. Difference of religion. There shall be no inheritance between a Muslim and a non-Muslim, but there can be wasiya. I mean, a Muslim can make a bequest to a non-Muslim relation who would have been a heir. The same also in the case of a non-Muslim. A Muslim can benefit from the estate of a non-Muslim by way of wasiya, by way of bequest. A child that is born out of wedlock shall not inherit the man responsible for his pregnancy. However, such a child shall inherit his mother. Of course, here there are differences of opinion, even though the opposite opinion regarding whether to let a child that is born out of wedlock inherit or not is a minority opinion. But in a case where the father, the biological father, accepts the son, accepts the child to be his own, even though he was born out of wedlock, and there is no counterclaim. It is not as if the woman who gave birth to him, the mother, was the wife of another person, while she is the wife of another person. Then she got pregnant for another one, and she knew that she knew the biological father, and the biological father accepted it. In such a case, he cannot do that, because technically, when she gives birth in the house of her husband, the child belongs to the husband, except if the only way for the husband or for the child not to be attributed to that father of his is through the judicial oaths. That is the li'an. That is the oaths of cursing the one who told lies. The modes through which heirs inherit are fixed share by agnation or by both of the above. The fixed heirs are clearly stated, which is starting from 1/8 For the wife whose husband has a child, then 1/6 for a mother who has, whereby the deceased left behind children, his own children, biological children, his own children, or there are brothers to the deceased. And also, it also belongs to the father, where the deceased, he left sons. Then there is 1/4, which is for the husband, where the wife has children, and for the wife, where the husband has no children. Then 1/3, I should have mentioned 1/3 before a quarter. 1/3 is for the mother, where the deceased left, where the deceased did not leave a son, and there are no brothers. And then also 1/3 is the portion to be given to maternal brothers, where the deceased died without a son and without a father. In such a case, his brothers on his mother's side, they will inherit 1/3 and share it equally among themselves. Even if they are men and women, here the distribution shall not be between a male having double the share of a female. Then there is 1/2, which is the share of the husband, where the wife has got no son or has got no offspring. And it's also the share of the daughter, where she's only one and there is no brother to her. She doesn't have a brother. And it's also the share of a sister, whether a consanguine sister, or that is a full sister of the same father and mother, or in the case of a sister that is the same father, a paternal sister, where there is no consanguine sister, and she doesn't have a brother, she will take 1/2 of the estate. And then 2/3 is for 2 daughters, is for 2 or more daughters, where there is no son, they don't have a brother, or sisters, full sisters, or paternal sisters, where they don't have a brother, or yes, where they don't have a brother. So these are the basic fixed shares. The fixed shares: 2/3, 1/2, 1/3, a quarter, 1/6, and 1/8. By agnation, normally it is the residue of the share, which is taken after this distribution. Now, after the determination and allotment of the prescribed portion due to each heir, the heirs or some of them may agree to vary the prescribed distribution formula based on their mutual consent. Sometimes it happens when you have several sons and very few daughters. Maybe you have like 9 brothers and only 1 sister. Now, the amount that the sister is going to get is half of the, she's going to get half of the share of each of the brothers. Now, the brothers can decide among themselves, after the distribution has been done in theory, then they will say, from our share, we are going to contribute what will bring the share of our sister to be equivalent to our own share. That is permissible, but not to change you cannot change the order of the inheritance. So it has to be, in theory, this is how it is done. Then afterwards, we are able to make this kind of settlement. That is why they say it is permissible to do sulh, that is to do peaceful settlement, or peaceful, to agree among the shares, the heirs themselves, in matters of inheritance. So where it becomes the benefactor is getting more, each of them is regarded as given a donation, and he is regarded as a receiver of the donation. If there is a delay in the distribution of the estate, that shall not be permitted, where even one heir claims to suffer harm on account of the delay. Normally, this happens. You find elder brothers, they are holding the shares and not distributing it, while they have got younger ones who are in need to take care of themselves, and they are in need of support, they are in need of the family, of the wealth, or they are in need of their share, and they delay. In such a case, it is not permissible to delay. because anything that brings harm under the Sharia is regarded as unacceptable. So in such a case, the heir that is making a claim of suffering harm on account of that delay, he can present his case before the court, and the court will intervene. In fact, even foreign parties, third parties who observe such a thing happening, they can be empowered. They can be empowered to go and make a case. And this is what we did in the draft of the proposed Kano family code, Muslim family code. Based on what the Fuqaha have said, we said that such a code, if passed, it will entitle third parties to make a case before the court that will compel the rest of the heirs to come and distribute the estate when they notice that some of the heirs are suffering harm on account of the delay in the distribution. So in conclusion, I just talked about the estate, the Wassiya as part of the estate planning and also the question of Al-Mirath. Al-Mirath could only be, that is inheritance, could only be regarded as part of estate planning in terms of just understanding it and understanding some of the issues, but you cannot plan for it because this is not something which is in your hands. It has already been done, but understanding the principles of Mirath will help in the estate planning, in the other tools of estate planning, like the tool of Waqf and the tool of Al-Wassiya. Whatever your category that you are doing it, what tools you decide to take, it will depend on your category. And also its ultimate goal is to be determined by the specific goal of the individual that is doing it. And we have discussed these two tools as tools of Islamic estate planning. And we hope this kind of speciality that FBN Quest and Metropolitan Law Firm are spearheading, because this is so far as I know, these are the institutions that are actually bringing to the fore in our society the essence and the importance of estate planning as part of Islamic financial planning. This is indeed a very laudable effort, and awareness in this is going to alleviate a lot of the suffering that is being that many people are suffering on account of differences and on account of issues related to distribution of estate. Thank you very much, and I apologize for going beyond my allocated time. Assalamu alaikum wa rahmatullah.
Alaikum salam. Thank you very much, sir, for always sharing your profound wisdom. Today we have learned a lot, and in our next webinars, which we had earlier said is a series, we're going to talk more about all of this and how you can also be able to give gifts according to the Sharia. Islam has provided for everything, like we said from the start. It has even provided for hermaphrodites. So it means that we have everything in place. And Dr. Bashir, thank you very, very much. Now we'll move to questions and answers session, which I hope will be very interactive. We have questions we have a few questions which I would like both speakers to address, but I'll start with Dr. Salahuddin. Dr. Salahuddin, Abubakar Razak asked that can a Muslim have a will when Islam has prescribed how inheritance occurs? Dr. Salahuddin, are you here, please?
For the question, if I get clearly said, can a Muslim have a will when Islam has prescribed for how how the banquet of the deceased should be shared. Is that the question, if I get it right?
Yes, correct, sir. Correct.
Yes, yes. Yes, a Muslim can have a will, because like we said, the will is not just the sharing of properties. It has, and I'm sure, alhamdulillah, we all listen to Dr. Bashir very well, and I'm sure we benefited so much from that. Beyond the property stuff that are inside, there are other things that can also pass along that we need to have. So it's not, the will is not just, okay, so what I left behind to be shared. What about those that are right on me that I need to also give to others? They all form part of the will. So yes, even for what needs to be shared can be documented. But the thing is, when it goes beyond what is required by the Sharia, that is when it is thrown out by the scholars. So we can have a will, inshallah. So,
thank you very much. Another question came from Aisha Rimi. She had asked if the recordings will be shared and if the slides will be shared. That we will have to ask for the consent of the speakers to see if we can be able to share, and then we will get back to you, inshallah, on that. The next question I'll ask Dr. Bashir is from Abu Bakr Musa. He had asked that what is the superseding practice in the case of a sick father at the point of death? I think he means that a sick father at the point of death makes a will in favor of his caring son only.
Yeah, Bismillah, Alhamdulillah, wa salatu wassalamu ala Rasulillah wa ala alihi wa sahbihi wa man wala. Yes, if a father makes a will, a dying father makes a will in favor of his dying son, then it is subject to the consent of the remaining heirs, because the Prophet sallallahu alaihi wasallam has said, "La wasiyata liwarith." There is no bequest to someone who is a heir. But it is not an outright prohibition. No, it's an outright rejection. He can decide to do that, but it is subject to the agreement of the remaining heirs, all of them or some of them. So if all of them agree, then he will have the will, the amount as willed by the father. But if only some of them agree and the others do not consent, then the proportionate amount that will aggregate to the consenting heirs will be the one that is due to him. Yes, but it is quite acceptable that there is nothing to prevent the father doing that. The same also, it can happen with wives. A husband, maybe he is sick. His elder wife, she is there with her grandchildren. She doesn't bother about him because she's become already a grandmother. She's there with her grandchildren, and he is there miskin. He only but he has this caring wife who maybe she's newly married to him, or she only has sons. She doesn't have grandsons, but she's committed to him, and he can decide to also give a will to her, make a will to her that will take care of her, especially knowing that her own children are small. But it will all be subject to the consent of some or all of the heirs. Thank you.
Very much, Dr. Bashir. Okay, there's another question coming in. It says, okay, what if the father now during his lifetime says, like, shares in a company, and he says, okay, his caring son or the most productive son is going to take like 50% of that company, and that company is huge, and it constitutes, let's say, more than 2/3 of the assets of the deceased. Perhaps he's gone. What would you say to that? But it has been proved that during his lifetime, the son is very productive. He's done better than all his children, and he feels that he needs to compensate him. But he didn't want to do it during his lifetime. He wants to do it after he's gone. What can you say about that?
Yeah, the first thing is that the amount that is bequeathed, it has to be reviewed. It cannot be up to two. It cannot be 2/3 of the estate. It can only constitute 1/3. So it will have to be deducted. That amount has got to be cut from 2/3 of the estate to what will make it only 1/3 of the estate. Then, if it is still made 1/3 of the estate, it will be subject to the consent of some or all of the heirs. And the ones, if they all consent, then you'll get the whole. If they don't consent, you'll not get anything. And if some consent, you will get a share that is proportionate to what will be the entitlement of the consenting heirs.
Very well. Thank you very much. The next question is from Sikiru Rufai. It's from Oke Ajayi Udus. He says, if Sadaqah is restricted to 1/3 of an estate, if a testator wants to do a waqf, is it also restricted to the 1/3, or can he do it from the 2/3? Dr. Bashir, please.
Yeah, there is no restriction on waqf if he's doing waqf during his lifetime, so long as the waqf is not done during his terminal illness. If it is while he's healthy, hearty and healthy, he can make waqf for even all of his property and decide to do that. But wasiya, because it's effective, it is to be executed after.
We can't hear Dr. Bashir. We lost him, but we can continue. Dr. Salahuddin, there's a question. He said, I'm a little confused. From Sikiru Rufai, he said, I'm a little confused. Dr. Salahuddin refers to wasiya as a will. My understanding is that it is a bequest which has a limit of 1/3 of the estate after the funeral cost and death. Dr. Salahuddin.
Thank you. Lost Dr. Day, so when he comes around, inshallah, he will take off. But this question, I also read it in the comment box. Well, I don't know where the mix-up came from, but I said the word bequest was used consistently by me, and I also mentioned what percentage it needs to be, which is what ratio it needs to be, which is 1/3 of it. So, but if in the course of my presentation you get it mixed up, sorry about that. It's not intentional. Thank you.
Okay, the next question we have a few more questions.
Sorry, Hani, I got disconnected.
Okay, Doctor, can you continue with the question?
Yes, just to conclude on that question, that is, if he decided to do the work while he is in a state of terminal illness, here he will be restricted to 1/3. That is, and if he decides to do work and wasiya while he is terminally ill, then the total of the waqf and the wasiya is limited to 1/3 also. That is the sum total will all be limited to 1/3. Thank you.
Okay, and then there's another question from Adam Yusuf Muhammad. He said, Assalamu alaikum wa rahmatullah. May Allah preserve you all. Is there any part to be given to a mother out of her son's inheritance who lost his father early, where the son's inherited from his father was not completely shared until after the son died?
Okay, the son's share from the inheritance of his father was not completely shared.
Yes.
And then later on he received it was not completely shared, and then the mother died. Will she be entitled to that residual amount of what was not shared? Isn't it? If so long as she died, so long as she died before the son, she died after the son, then whatever was the entitlement of the son will also she will become a heir to that part. So she will be a heir, definitely.
Okay, alhamdulillah. This question from Rahma Oladejo, she said this question is directed to Dr. Bashir. Can we say that the deceased failure to complete his marriage gift will make that a dent against his estate? That's one question. And the second one, if an heir kills the person to be inherited in self-defense, e.g. if a wife kills her husband who was attacking her, does she have to pay the diya? And does she also not inherit from his property? Thank you.
Well, okay, the first question regarding the marital gift. The marital gift becomes a debt from the so it will have to be taken out of the estate before the wasiya. It will have to be taken in from the estate immediately after the funeral expenses and the payment of deliverance of collaterals. But the question of a wife killing her husband in self-defense, when a wife kills her husband in self-defense, the husband is not entitled to qisas, that is, he is not entitled to retribution, nor is he entitled to blood money. She does not pay diya. His blood, it goes without anything. But the question of since there is no diya, and in it, she was actually denied diya. Will she inherit him? Will she inherit him? When you come to look at the literal wordings of the Prophet sallallahu alaihi wasallam, that la yarithul qatil, that the one who kills, he is not, he cannot inherit, then you will say she cannot inherit. But when you look at the fact that the hadith means al-qatil, the one who deliberately murdered a person, but the one who killed a person unintentionally, he is entitled to inherit from him. It's only the diya that he does not inherit. So one can say such a wife shall inherit. But I don't want to give fatwa on this because I'm just using analogies and I don't have any statement from the fuqaha regarding this. So maybe inshallah when I get it, I will share it with Hani, and you can maybe share it in the email of Sister Rahma, inshallah.
Inshallah. And the next question again is that how can adopted children inherit from you since you love them like yours?
Yeah, adopted children, the first thing is there is no adoption in Islam. There is custody, there is fostering, but there is no adoption. You can't take someone and you say you adopt him to be your son, but you adopt him to be your ward. You adopt him to be under your care. Such a person, he cannot inherit because inheritance is either through marriage or lineage, as we saw. So since there is no lineage, there is no basis for inheritance. So the only way for you to make him benefit is you come and look at how the estate is going to be divided. So you make a wasiya for him that will secure for him the amount maybe that will be equivalent to your children, to all your children, and you can do that. And because wasiya, you can always change it when the expected sharing ratio or distribution changes. You can also change the wasiya in favor of the adopted ward. But he cannot inherit. But the same thing can be done, which is through wasiya. Or you can choose even to do waqf. That is, you can choose to do waqf so that he starts benefiting right when you are alive. And you can also choose to give him a gift that he can enjoy, that will be like, that will give him the equivalence maybe of what he would have gotten if he were an heir.
So, thank you, Doctor. This question was from Hajia Ireti Kingibe. If she has any more questions, we'll come back to you, sir. And there's another question. This is for Metropolitan. They said the key is from Abdullah Ahmed. The key message I got from this masterclass is the importance of having a will as soon as possible. How can you help me draw up one? Like yesterday. We'll draw it up as soon as you're ready, inshallah. Dr. Salahuddin, please, how can, from Jazira Amadou Bello, she said, how can we now communicate to the public on Islamic finance, especially regarding Wasiya, since so many families are suffering due to the absence of Wasiya? Dr. Salahuddin, please.
Thank you. The first thing is that we like Dr. Bashir to thank the entrepreneur FGN Quest for this wonderful. We just need to take it forward. We not allow it to stay here and die here. This is a big opportunity for all of us. And we just need to make sure that we hit the road. All of us here have to advocate of this. Request by people for the site. I think this is one of the ways we need to hit the road. We need to hit the road, and we need to request people so that they can ask for this. This good call is that for all of us, and I think it's a good one for us to actually put forward. You talk that a lot in need of this information. I put the flyer on a Facebook page, and when I checked the review last night, 709 people have already looked at it, and I've seen a lot of comments. So it means that it is something that is lacking in our community, and we need it, and we should all be advocates of it. For me, I'm going to be an advocate of this, and I want everybody also to commit to it. Inshallah, will be beneficial to all of us. Thank you.
Inshallah.
Okay, sorry, Umahani, I need to excuse myself because I'm in the mosque. I'm just out and already they are waiting for me. I'm the Imam. We have to pray now.
Okay, sir, just one last question then before you go. I understand. And this question is meant, it says, Assalamu alaikum. This question is for Dr. Bashir, please. We're submitting this question for clarity. When one gives out a loan to a person, the requirement to document it, is it compulsory? What if one does not discuss it for the protection of the privacy of the one you gave the loan to? Is there any issue that one's dua will not be answered if the loan is not documented? Can you explain, please? This is from an anonymous attendee.
Okay. The requirement to document a loan is a recommendation. It's not an obligatory act. So if a loan is not documented, there is no sin on that, and it does not lead to the dua of somebody not being answered by Allah. There is nothing, there is no proof for that, and it is just maybe some saying that has got no basis. The verse in the Quran has clearly provided that there are conditions and there are situations when loans are not documented, and when you look at the spirit and the reasoning behind the legislation, it is to close the doors of disputes. And that is why alternatives were created. Like when you are in a state of travel and you don't find someone who will document the loan, then when you make the loan, the only way to secure it, you can secure it by using a collateral. So which shows that the act of actually documenting a loan is a kind of security for the loan. And this security is to secure the right of the lender and also to protect the borrower so that when he dies, he does not die and people do not know the rights and obligations that are on him. And also to close the door of disputes and litigations. So that is why we were asked to document. Now, this kind of instruction, when it comes, and when you see all the context within which it was legislated, you will understand from it that the instruction is not meant to be an obligation, but it is meant to be a recommendation and a direction, and taking people, leading them to what is regarded as best practice tradition.
Thank you, sir. Thank you very much. We will let you pray. What other questions participants have because of timing issues, we will just ask you to, we will respond to you. You can send an email to consult@medlawfirm.com and FBN Quest trustees as well. Please, we will share the details of the the communications with you. And we will just round up here. Thank you very much. Thank you very much, Dr. Bashir. Thank you very much, Dr. Salahuddin and Mr. Rotimi Obende for a very profound presentation and knowledge sharing program. And we hope that during our next webinars, we'll be able to explain a lot more. And so we can understand our responsibilities as Muslims to be able to share our estates as the Quran and the Hadith will say. Our next webinars will be on Waqf and Hiba. Hiba is gift, and then Waqf is also a charitable object which Islam provides for any Muslim to be able to give out to whoever he likes. It could be family, it could be a general Waqf, like we're trying to do the Metropolitan Waqf very soon, which is going to be geared towards education. So Alhamdulillah, thank you everyone very much for this. And then we hope to see you again at our next webinar. Thank you. Assalamu alaikum wa rahmatullah.
Assalamu alaikum wa rahmatullah.